The genesis of the problem is a video shot by me in 2022 sometime. This video was not shot by me, but by one Faisal Puria, who got the snakes by the permission, took DC's permission, and a music video for shot. And then obviously we were there with there was a blog that I was with the snake. Now that blog is what relied. On that basis, his brother, Saurabh Gupta, files a complaint with the Gurgaon police station for registration of FIR and then a 156.3 resulting in FIR on that blog that I am being cruel to the animals. On that, a proper investigation is carried out and a closure report filed more than 1 year ago.
All right.
Malal Lochi may kindly have the closure report now.
So now she invoked 156.3, then closure report was filed.
Yes.
All right.
For that.
Yes.
Malal may kindly have the closure report, which
That's by the private respondent.
no, we filed the document.
No. Who filed the 156?
Gurgaon police filed the closure report.
No. 156.3 who's filed?
Yes, 156 brother Saurabh Gupta of this complainant.
Oh, brother of the complainant.
Yes, and real brother of this complainant.
Okay.
And what he does is this Saurabh Gupta is a witness in this FIR also.
All right.
Cancellation.
That was closed.
That was cancellation report filed before the court.
All right.
Malad Lochi may have
Closure report was filed. All right.
Not satisfied, they also filed. They also simultaneously do that. They get in contact with Rahul and my lords. In that matter, one Himendra was the one who had supplied the snake and he had taken all permissions. And they get in touch with Rahul Sape and called them to a place, a banquet hall, saying that we are organizing a party. So get this snakes for us. 5 people, Rahul, Titu Nath and his other members. I am nowhere in. I am not present, nothing, no recovery from me. When they come, they are arrested because he is there. Forest department officers are called and the police is there. So they are called with 9 snakes, caught with 9 snakes and 20 which till now they call as snake venom. That FSL says it is antibodies of snake venom, which are two. Lordship may kindly have Annexure A13 of my additional documents, page 29. This is very important. Even in this additional affidavit, they say snake venom, and I'll tell you.
Where are you reading?
Page 29
of
the additional documents, Annexure A13. Additional document filed by the petitioner. It was filed along with the main file itself, SLP itself.
Yes. Page 29. Page 29 is the...
Yes. Page 29 and Annexure 13. A13.
Okay. Yes.
But even in this additional, they say it's snake venom. They take opinion of snake venom, whereas it is antibodies of snake venom.
Antibodies. Yes.
Antibodies. But let me just give the procedure how antibodies are there. Antibodies is given as a cure of a snake bite. For getting those antibodies, small quantity of, and it's a scientific process, small quantity of snake venom is injected in horses or sheep, and thereafter that antibodies are extracted, and then that is used as a cure for snake bites. This is all a scientific process, and mostly the snake charmers have it as in when they have a bite, this is used by them.
So it will be injected on a horse.
Yes, antibodies are recovered of this snake venom are recovered in this manner.
And from the horse it is recovered.
From the horse, because then it generates antibodies and those are then recovered.
Yes.
It's like a medicine, Malot.
Yes, all right.
It's in a form of a medicine.
Yes. What is administered to the horses?
Malot, a very small quantity of snake
poison.
It creates antibodies.
Yes. Yeah. Antibodies are produced and those antibodies are used as a treatment of snake bite, and that's and these are from the blood. It is not that I can go and take out the antibodies like this. It's a scientific process.
What are the characteristics of these antibodies which is consumed? Apart from curing the snake bite, what are the other
neurotic effect it doesn't have? I'm coming to the FSL report. I'm coming to the report of the 3 doctors on the basis of which they invoke NDPS Act. Lordship may now kindly have the report of the doctor they take.
This was recovered from whom?
This was recovered from Rahul Sapera. Not me, I'm not even present. And only substance, this 20 ml liquid, and which they call is the narcotic substance. This is the only, and those 5 persons are there, they are arrested, I am nowhere nearby.
Yes, yes.
Lordship may kindly now have the report of the doctor, 6 doctors.
Yes.
That's page 46, annexure, page 36, annexure A16, same file.
Yes.
Malad, Lordship have seen from the FSL what is recovered is antibodies of snake venom. And what they now do is question 1, page 37. It's an expert body which they get engaged and take. Just can snake venom be used for recreational activities?
Yeah.
Then second is which are the common snakes for recreational activities? They say cobra crate have neurotic effect. Then can snake venom be used as substitute for any drug? It says snake venom can be used as a substitute of any drug as published in various articles and standards, but some of the neurotoxic results in a centrally mediate opiate, independent, and they can be substitute, but not, they have a different effect. Because unlike opioids, snake venom used does not show any withdrawal symptoms or tremors or addiction or any side effects. Lordship has on page 40.
Page 40.
Page 40, question number 4.
Yes.
So the properties are totally different. But what is recovered is antibodies. And now I'll come to that question. Question number 5. Is anti-snake venom, which is antibodies, used for neutralizing effects during recreational purposes orally? Anti-snake venom is commonly used to treat snake envomation by intravenous route. It's not that you drink it like this and you get the effect. It's a medicine. And what is recovered is this, and it has no neurotic effect.
That is only usage. My brother is asking whether this anti-venom, if it is taken orally, will it have that neurotic effect? There's no.
They don't take they don't ask any question from the expert body.
See, whether it's there or not, it's a matter for trial whether it gives or not. But at this point of time, how do we give a finding that it is not giving any?
Prima facie, it is for them to show that it has antibodies of snake venom has neurotic.
Already last time.
Yes, it is for them to show. What they are asking is
from this material produced, we are not able to come to the conclusion. Both are different, though.
Both are different.
But one would create the neurotic effect or not. We are not able to figure it out.
They have to show. There is nothing. I can put on the literature on this aspect. Okay. There is no problem on this aspect.
Yes, all right.
And secondly, my argument was, Lordship, they have invoked Section NDPS Act.
Yeah.
That it is a psychotropic substance. Right from Rao Shiv Bahadur, it is well settled that if you invoke a provision, it has to be an offense on that date. Merely by the ipsy-dixy of the prosecution, they cannot make a psychotropic, any substance as a psychotropic substance. Lordship may kindly have the NDPS Act.
Yes.
Section 2, subsection 23.
Yes. Yes. Yes.
Lordship may kindly have psychotropic substance. Lordship has the definition.
Specified in the schedule.
Yes.
So according to this, not specified in the schedule.
It is not. So, my lords, on the day when I am, this offense is put on me, the FIR is registered, I am alleged to have committed, which is, I am not the one, the other 5 have alleged to have committed, it should be an offense as per the Act. They can't, by the basis of opinions, make it as an offense. Well, it is nowhere in the schedule, and even in their additional affidavit, they have not been able to show that it has been a few offense in the schedule.
All right.
Now, my lord, second aspect after this, my lord's Lordship sees my second submission. This was that no NDPS Act was made out. Lordship may now come to the FIR, what it said, how they rope me in this FIR. Well, this page 59. Oh. It's like exactly.
Yes.
Page 59, Lordship has the complainant is Gaurav Gupta.
Yes.
Page 59 of the SLP, Lordship has got it. And next up,
SLP. All right.
P4. Next up, P4.
Yes.
69.
59.
Yes.
Yes.
Their grievances that I shoot videos, one video,
69, 59.
59 minutes.
59.
Yes.
This, so they give that I am this organization, which I am shown he is no more a member, he has no authority. So there is a YouTuber so-and-so who makes videos with snake venom and live snakes in farmhouses in Noida and NCR. This is all, there is no substance except for one video which I say, which I own. There is nothing of this. And other members of the YouTuber, they illegally as a gang engage parties in which foreigners come, from where there is no evidence which has come on.
Now it says Gaurav Gupta, Animal Welfare Officer in PFA organization. He is not a member, is it?
He is no more.
Not an officer.
Not,
even on the date of the complaint.
No. Lordship may kindly have, and I'll show how it's annexure P1 itself of this petition. Lordship has this SLP petition annexure P1.
Yes.
P1 itself shows. Page 44. Because he engaged in complaints against some other people. This is their method of extortion also, Maloj. So, Lordship has, this is 4th of January 22, annexure P1. It is brought to the notice of the board that you are using, it is addressed to Gaurav Gupta.
Yes, all right.
Harvard ID number, which has expired in February 2020.
Yes.
In this regard, it is submitted that the board has issued a circular that all these have expired. Last paragraph, therefore, in view of this, directed to submit the original Havo ID so-and-so to the board. He is not there. P2 is, he was asked to surrender the documents, page 48. 27th of January 2022.
Yes, all right.
So now, Malaj, back to annexure P4.
Yes, please.
Malaj, after the investigation, they have not found that I have ever conducted any party or anything or involved in any of these things. Except that one video blog, there is nothing in it.
You participated there.
I participated.
But then you are found having the snakes in your hand, is it?
Yes, Malaj, there is. Malaj, which is part of another FIR in which I am saying cancellation is filed. And the Noida police has no power to investigate because that's an incident which took place in Gurgaon, Haryana. That farmhouse where that video was shot was in Haryana. So Haryana police registers FIR.
Against that one.
Against that same video. Files a cancellation report. Noida police had no jurisdiction. But both the brothers were annoyed and they wanted to catch some limelight, and that's why all this has happened. Now, Malak, there is no evidence. So, upon this, Lordship has...
So far as this occurrence concerned, is it connected with the earlier one or is it not connected?
Nothing. These are two separate incidents.
I see.
This incident is, he makes a phone call to Rahul Sapera that I'm organizing a party.
Who makes the call?
The Gaurav Gupta, it is he calls,
yes.
And then those 5 snakes.
So how do you get into this affair?
Nothing, my lord. There is no evidence. That's what I'm saying. Except what they say is because I am organizing in this, I engage parties. There is no evidence to effect. I am not present. I am not, nothing recovered from me. What they say is that this one person knew this. What is the name of Rahul? Knew one Rahul knew one Ishwar knew Vinay, so Vinay knew me, so I am involved. It's something like my friend dealing with some other people and I get involved into it. If I've spoken to him for 5 times and he's been speaking to 2, 3 other people, I get involved into it. This is the only thing which they have. No evidence that I have ever conducted any party. No evidence except that video. That video is there. I don't deny it. And therefore, Haryana Police registers FIR, says all permissions taken. There was no cruelty, everything seen, and they file a cancellation report. Whatever is the outcome, the trial court will decide it. For the same thing, I can't be tried again twice. Now, Lord,
Yes.
on this basis, Lordship may kindly have, they just go through that this YouTuber on second, Lordship kindly have page 59, last few lines.
Yes.
He says how we called. After this,
Yes.
I called them to the Chevron hospital. We informed on 2nd November 23. We informed the DFO as soon as these smugglers, that's Rahul, Titu Nath and all, came to the hospital. We talked to them and expressed.
That's all. This is FIR. Let us see the charge sheet. What is how do how do they implicate you?
Yes, my lord. Lordship, I kindly have the charge sheet now. Page 40.
Page 40 is it?
Page 109, my lords, may have.
109.
Annexure P14.
Yes.
Lordship may have.
Yes. Yes.
Lordship has it, page 147.
147.
Yes.
Yes. Yes.
Again, they say, I've been conducting parties, no evidence, so I called Rahul, and this, he says he's attached, he's protected. So this discussion between when he calls Rahul, that is one CD with them.
Where, how are you implicated in that charge sheet? Please read the relevant part.
That's even I am at a only on the basis of disclosure
Now,
of
based on this information, the
Not page 149 may see.
149.
149
Yes, what is it?
Informant contacted Elvish Yadav for conducting rape party. Page 147. Informant contacted.
Milord, may it come to
No, there is
149, Milord, second last para, the main accused, Rahul Sapera. There onwards, Milord.
Page?
149, Milord.
149.
Yes. The main accused, Rahul Sapera.
Right, Sapera, yes.
Yes. May I read, Milord?
Yes.
The main
Sunday is created a channel. His medium is connected to.
I am not connected to Rahul Sapera. No evidence.
Milord, this will come.
Several times.
No.
And he has taken venomous mistakes.
You can take.
That's correct. All right, we'll take that as it correct.
Milord, it's a disclosure statement in police custody. That is the only evidence, disclosure of this accused in the police custody, and that too on the after 5 days. First disclosure, he doesn't name me. There is no phone call between me and Rahul Sapera.
Rahul collects venomous snakes and
who is a Luke procures venomous snake through
his friends, which Rahul makes available. Milord, this is a disclosure statement, which is
this is certain CD number so and so.
This is disclosure of Rahul. No evidence.
No.
There is not even a phone call of mine with Rahul.
That's a matter of investigation.
Yes, Milord?
That's a matter of investigation.
Rahul
No,
says
investigation is complete. Charge sheet has been filed.
No.
So they have not been able to get any evidence that I ever procured from him, or I have ever contacted him, or I have this. This first disclosure, he doesn't even name me. Second disclosure, he names. Lordship may kindly have those disclosures. I'll give the disclosure.
CD numbers 11, 12.
I will read those. I will read those, my lords.
Clearly recorded.
I'll read those CDs number. Yes. Well, let's kindly have an extra P6, page 65.
This is the CD means it's a statement given before the
Police officer.
I see.
Police officer while in custody and he's an accused. Lordship may kindly have an extra P6. Third, he is arrested. Rahul. Page number is 65.
65.
Yes. I have an extra P6 with the SLP. 3rd November 23. He says statement of Rahul so-and-so. 32 confessed his crime and stated that my father is so-and-so, do the working of playing drum, flutes, etc. at wedding parties and other places. Wherever there is a demand for snake venom and live snake, I take snake venom and live snakes there. This snake venom and live snakes are given to me by a man in Delhi, Badarpur, whose name and address I do not know. He is found standing near.
All right, we got. See now the charge against you is that that you have procured it from who's it, Rahul through his friends. That is Vinay Yadav and Ishwar Yadav.
I procure it. There is no recovery from me.
We understand the charge. We'll ask them, no problem. Yes, all right. But there is some evidence on the charge sheet how they. What is the material? We'll ask him, that's all.
Yes.
We will not go into the quality of the material. The material is available not based upon that any statement is given by this person.
The petitioner was using a virtual number also, my lord, to get in touch. That is also incorporated in charge sheet, my lord. So
we'll come back to it.
Yes, ma'am.
Yes, all right.
My lord, lordship may have. Then his second disclosure is recorded, which is the maximum they have, which is again a disclosure statement. Page 66. This is after 4 days he's in custody on the 6th November.
That's all right.
MINX is a snake charmer. I get that venom when I go to Elvish Yadav's party.
It is hit by 25, therefore we will ignore that. We want to know what is the material. We'll ask him, no problem.
Yes, my lord. Now, my lords, these are two aspects. One is with regard to the fact whether it's not an NDPS substance. It's not a psychotropic substance under the Act, so I can't be charged for it.
Yes.
No charge sheet for that could be filed or no cognizance be taken. Second, it's a case of no evidence against me. Thirdly, the legal issue that it could have been only on a complaint case, my lords, and not on a police report. And Murad Ali and Jeevan Roth are the two decisions thereon. My lord, that in a case where it is under the Wildlife Protection Act, only and only, even if the police officer was authorized, he could have filed a complaint case and not a police report. And no cognizance could have been taken on a police report, only on a complaint case. Melod para 13, if lordship has in Murad Ali,
yes.
Page 16. Our compilation, if my lords have it, on the last date I handed.
Yes. Yes. Page 13.
Page 13. Because the issue in this was whether 210 proceeding could be done because police officer investigated and filed the complaint as also a charge sheet.
Yes.
So they said even that's not permissible. Para 13, yes. If lordship has, yes. Page 16. What emerges from a perusal of these provisions is that cognizance on offence under the Act can be taken by a court only on the complaint of officer mentioned in 55. The person who lodged the complaint on so-and-so, lordship may come to the last 4 lines, but whereas here, cognizance can be taken only in one way, and that on the complaint of a particular statutory functioning, there is no scope or occasion for taking cognizance more than once.
Yes.
So they said it is only. Now, TOHO, the Transplantation of Human Organs Act, has a similar provision. Identical provision, lordship, Jeevan Roth's judgment, which starts from page 24 of this compilation.
Yes, at page 34.
Page 34. Well, if lordship has 34, section 22 is a parameteria, same provision. Well, lordship may also have page 29.
Yes.
Paragraph 6. The High Court didn't advert to the fact that whether a complaint is not a police report and cannot be treated as such.
Yes.
Page 30, last line. They reproduce that the complaint does not include a police report. I am not taking my lords to CRPC, but the provision itself says, section 2D, when it is a complaint, it excludes a police report. Expressly it will be. Now, my lord, 34, section 2022 is reproduced. Now, my lords, may come to page 36.
Yes.
This was a case where it was transferred to CBI. They said even then, para 26, it is well settled principle of law.
That's correct. We have seen that. Yes.
On page 36.
Yes.
It is well settled principle of law that if a special statute lays down procedure, the onus lies, the ones laid down under the general provision statute shall not be followed. Now, para 28, Lordship has it.
Yes.
To put it differently, upon completion of the investigation, an authorized officer could only file a complaint and not a police report, as a specific bar has been created by Parliament. In that view of the matter, the police report being not a complaint and vice versa, it was obligatory on the.
All right. Yes. Yes.
Yes.
Anything else you want to say?
On an extent to say whether CBI could have filed that
Very well.
complaint also. Now, Malad, thirdly, so both on facts there is no evidence, on law no cognizance could have been, and my challenge was both to the charge sheet and the cognizance. Malad, I am here only for myself, not the other co-accused. Now, Malad, may kindly have the Gurgaon closure report for a minute. Malad, how they bring in that facts of this case also. These are two different incidents which have been brought into over here. Annexure 24, Malad.
Yes.
Please.
Are additional documents. It starts at page 57. And Lordship may have who's the complainant over there.
Please.
Page 57. Annexure A 24. My additional documents, Malad. I'll buy the petition.
Page 54.
I'm sorry, Malad, we are just, I can prepare a convenience.
No problem. Page?
Page 57.
Yes.
Lordship may kindly have 58. Who is the complainant? Saurabh Gupta, son of Ashok Kumar Agarwal, the brother. And this Saurabh Gupta is a witness in this FIR.
So he's a witness in the present affair.
Present FIR.
Yeah. Yes.
And both are filed around the same time. When the police doesn't reach, they go in 156.3 Saurabh Gupta. Now, Lordship may kindly have. This relates only to the block. Malad.
There is also section 50 of the Wildlife Protection Act.
Yes, Malad.
Final report.
Final report. Same block. Lordship may has
Yes.
page 63. The URL link of that blog is mentioned. Same blog which they are claiming now. Lordship, I've got it last but 6 lines. Further, the said video can be accessed through link bearing number so and so.
Yes. Yes.
Now, Lordship may kindly have page 65, how they come to this conclusion.
Yes.
After noting what are the FIR and all that contents. Page 65, bottoms 8 lines. Upon reviewing the contents of the complaint letter, it was found that offences under 51 on wildlife and 11 of the prevention of cruelty to animals and 294 and 34. 294 is invoked over here also. Has been committed. Accordingly, the above mentioned case was registered and the initial investigation was carried out by so and so. During investigation, Hardik Anand was included. This Hardik Anand is the one who gets the snakes over there, not Rahul Sapera. He stated that exotic snakes were used in the shooting of the song 32 boar, which were brought by him and for which he holds permission. Hardik.
Very well, we have seen that.
And Malad, we took the permission, they took the permission from DC and all this. This has been file closure report. Malad, Lordship may kindly see. Additionally, if Lordship has just above para 17, 8 lines. Additionally, a notice was issued to the Wildlife Department, Gurugram, and a point reply was obtained based on which the review, they concluded point by point that no cruelty to snakes was observed in the video and all animals used were exotic species whose possession and usage do not constitute an offense. Well, this is, they file it, it is before the court concerned. If summons are issued, I'll face the trial. But I can't be made to go for trial for 2 places by 2 brothers like this.
Yes.
Subject to
marriage. Yes.
My lord, I like to, my lord, may come to page 150, my lord, of the SLP, my lord, charge sheet. I'd like to read 3-4 paragraphs, my lord.
Yes. Yes.
My lord, middle of the page, my lord, page 150 of the SLP charge sheet, my lord. According to the received report, the recovered snake venom was found to be venom of snakes like cobra, krait, russell, and saw-scale viper. The original copy of the investigation report in 3 copies is attached with CD number 22. During the investigation, upon obtaining and reviewing the CDR of accused Rahul's mobile number so and so through several glass cell, it was found that Rahul's V party so and so, who is Ishwar Yadav, resident of village Fajlipur, Haryana, with whom Rahul Sapera talks via his mobile phone or WhatsApp call, and the location of both was found to be the same tower in Gurgaon on dates so and so, so and so, so and so, and so and so. And Ishwar Yadav and Vinay Yadav are good friends, and Ishwar Yadav has a banquet hall restaurant, and is in this very restaurant Rahul and Vinay Yadav together planned the said crime. It was found that Ishwar Yadav and Vinay Yadav had talked to each other over 15 times on different dates, and Vinay Yadav and Elvish Yadav are good friends who keep talking to each other continuously from this. It is clear that Elvish Yadav, the director, did not talk to Rahul Sapera directly, but he remained in contact with Rahul through his associate Vinay Yadav and through Ishwar Yadav, or through his associate and by Elvish Yadav's
That's
associate.
correct. There's no difficulty.
Yes.
What is that to implicate him?
No,
See,
my lord, the matter which is being raised here is that the video relates to a Gurgaon music video, my lord. The music video is not in question, my lord. The video here in my lord is post the music video where they are playing with these snakes in a different manner, my lord. And there is not only one video, my lord. There is another video also in which a snake was found in a drum. That's second video, my lord. And then there is, my lord, a audio call, my lord, where the
counsel, all those things. See, they answer these questions.
yes, my lord.
First fundamental question is that under section 294.
284.
This will not come under the purview of the NDPS Act.
My lord.
Number one. The second one is if it is not come under NDPS, then that act will go. The second submission is under the statute, it can only by way of a private complaint by an officer.
My lord, that's
Number 3 is on merit. What is that to implicate? So we'll go to number 3 later with respect to this, whether phone calls would indicate or not.
yes.
Because he is not he is not otherwise connected with this, except to the fact that he was doing it earlier, that some his friends were in touch. He is not. There's no recovery from him, and nothing has been done. We will not even go into other aspect whether it's a snake venom that is used, because the materials will show it's only antidote.
No.
We are not going to conduct a roving inquiry at this stage. How do you maintain the complaint? How do you say the cognizant offense is made out? And which provision the cognizant offense is made out?
Schedule substance.
Yes, my lord.
It shows that.
Yes.
No, my lord, it is as of now, my lord, that is not included in the schedule.
Then NDPS Act goes.
My lord, but
Listen. See,
yes, my lord.
You may say you may be worst thing we are not saying. NDPS Act goes.
Yes.
Then we'll come under the other act.
The complaint is not filed.
So you have to file a complaint or private complaint.
My lord, for that we are before, my lord, it may be converted into complaint, my lord, if it is
that is what we are also contemplating.
Yes.
We are not going to give a clean sheet to that person. If he has committed something, it has to be done.
Yes.
But that is done by a proper officer.
Lord, all the recovery and everything was done by either they were police officers or officers of the forest department, my lord. And the complaint was not filed, they filed a charge sheet, my lord. Now,
how do you see?
Lord, it's a
how do you do
Lord,
this?
for that we are before, my lord,
See, when even if you find the charges approved, it should be through your proper authority now. See, now it raises a question with respect to the complainant himself. See, one thing we can say, subject to somebody's appeal, must be appealing complainant. His bona fides are absolutely doubtful. See, his brother has given the complaint earlier, and he is a witness here. That complaint is closed. Now even as against him, now his complaint itself says he's a member of so and so, but he is not so.
He is not so.
May I just clarify that aspect, Your Lordship? That's being wrongly interpreted. The FIR says Animal Welfare Officer of PFA organization.
Yeah.
PFA is a private organization, People for Animals Trust. It has got nothing to do with the document that is being shown to Your Lordship.
All right.
So that whatever show cause notices, etc. I've got.
Already then you show how our complaint is maintainable.
Your Lordship, on the merits aspect, Your Lordship, I can just.
Why should we go into the merits? See, we have a very serious doubt about your credentials, especially when your brother has given a complaint against that earlier block, and then thereafter he is also witness here. It seems that you are no credibility here.
I may just only take Your Lordships through one paragraph on the same page that Your Lordships are at, page 150.
Yes.
Just one paragraph I want to read, Your Lordships.
Why should we go into the merit when you have lack bona fides? We are not here to conduct.
It's my only complaint against this person.
See,
while the other
you are not able to deny at least the documents filed by them to show how you are behaving in these matters, in such matters.
Which is what I'm saying is, yes, that even when I initiated the complaint, I've not misrepresented to anybody that I'm some government officer. My statement is very clear that I'm an animal welfare officer of the PFA organization. It's clearly mentioned in the FIR. I nowhere state that I'm some government officer acting on behalf of them, and therefore you should listen to my complaint. Therefore, Your Lordship, I have not concealed anything. As far as the second complaint is concerned, Your Lordship, the closure report notice has so far not even been issued to me, my brother. So, Your Lordship, I contested whenever it
comes. Please don't say all this in
before. Whenever it comes, Your Lordship, I'm not saying that.
You
All I'm saying is, Your Lordship may see, I have placed on record, I have filed an application.
This is nothing but orchestrated litigation. We will not see. We will not. I think so far you are concerned, we'll throw you out. That's as simple as that. So far they are concerned, we will only say that we'll quash this and we'll say that liberty is given to the concerned officer to initiate action. See, we are not going to go into the merits of the case.
Lord may see the recovery, my lord. Also, it's annexure P3, my lord, of the SLP, page 49, my lord. Page 49.
Well, let's take them.
This is page 155.
Leave granted. The seeking to quash the proceeding initiated. That is, we quash the charge sheet and the subsequent proceedings. Punishable for the offence under section 284, 289, 120B IPC. Along with the provisions of the Wildlife Protection Act and sections. How 284, 89, they are all not cognizable, is it?
284 are based on that block only.
Yes, yes.
That's why I said that the club they are over here.
Yes, yes.
284, 289, cruelty to the animals based on that block only.
Yes, under the APC. Along with section 9/39/48A, 49, 50, 51 of the Wildlife Protection Act. See the notes is available. And section 22, 27, 27 is of the NDPS Act. The present appellant has come before us being agreed over the judgment rendered by the High Court. High Court has not gone into this aspect.
At all. Yes. Their version serious offence and
yes.
Dismissed.
Though arguments have been made at length, we are inclined to go into the only two legal issues raised by the The first issue is with this on the scope and applicability of section 2 subclause 23 of the NDPS Act 1985. The second issue is with respect to
section Wildlife Act. Section complaint.
Wildlife Protection Act.
Section 55 of the Wildlife Protection Act. Full stop. Based upon the set two issues, Learned Cynic was appearing for the appellant would submit that admittedly the cognizant the offence attributed under the NDPS Act is not maintainable as the psychoactive substance.
Subsection 23.
Yes, allegedly recovered from the co-accused does not find place in the schedule. This submission is made by the Senior Counsel, notwithstanding the fact that recovery was not made from the appellant, and the charge against him is to the effect that he used to place orders through his friends with the co-accused.
That too based on disclosure statement.
Who was in possession of the snakes based upon the disclosure statement. Insofar as the second submission is concerned, and a scenic was appealing for the appellant would submit that section 55, is it?
Yes, ma'am.
Section 50 of the So-and-so Act can only be pressed into service only by a private complaint by an authorized officer. It is a further submission of the City Council that the offences under the Indian Penal Code are not made out as they were the subject. They are the subject matter of an earlier complaint.
FIR 146
is the subject matter of FIR 146 of 2024 with respect to a block.
PS Badshapur, District Gurgaon.
District Gurgaon, which comes under the state of Haryana. Full stop. This complaint was given by the brother of the present complainant, who is also a witness in the letter. The said complaint was closed by a negative report.
That has been cancelled report filed by the investigating agent.
Pursuant to the investigation done by the jurisdictional police.
Yes.
The very same complaint has been factored into in the present one in order to bring section 284, 289 and 120B of the Indian Penal Code. Next one. Per contrary, learners counsel appealing for the state submitted that there are materials sufficient enough to implicate the appellant. Though the substance does not find a place in the schedule, the taking note of the affirmations made in the materials indicated in the report file, there is no need for interference. Even assuming this court finds that there is a procedural violation, the same cannot be construed to mean that the appellant has been given clean sheet. Next one. The Learned Counsel appeal for the complainant would submit that though the documents read upon by the Learned Senior Counsel appeal for the appellant with respect to his status is not in dispute, the present complaint has been given on a different footing based upon his status with respect to private organization.
I have never received any of those show cause notices. I am disputing those documents.
The documents, the more you say, the more we have to say something. The documents read upon by the counsel for the appellant, appellant is also disputed. In such a matter, accordingly, he supports the submission made by the counsel appealing for the state. Next part. We would only go into the issue. We're going to go to the two legal issues raised, as we find. So far as the IPC offences are concerned, they being the subject matter of the earlier complaint, they cannot form part of the present proceedings. Insofar as the issue pertaining to section, yes, to section 2 subclass 23 is concerned. Admittedly, it is not what is recovered from the appellant, but from the co-accused is cannot will not come within the purview of a psychoactive substance, having not found in the schedule. Full stop. Nothing more required to be stated on that. Though the Learned Senior Counsel appealing for the appellant may place lines upon various judgments. On the second issue also, we find that as per section 55 of the So-and-so Act, what is required is a private complaint by a competent authority. The said issue has been considered by this court from time and again. Also in State of Bihar versus Murad Ali Khan, 1984-66-55. This court was pleased to hold as follows. Page 16, para 13. Okay. Also. In Javan Kumar Raut versus Swanso, 2009-7 SEC 522. This court was pleased to hold as under para 34, page 34, at para 19 and 20. Also next para. In the opposite judgment, this court was dealing with the parameter provision like section 54. 55. We would only reiterate section record section 55 to understand the similarity between the provision dealt with by this court in the judgment refers supra and the one we are concerned with. Record this section 55 of the present act. Next para. In a recent judgment rendered in BN John versus so-and-so, it has been held by this court in paragraph 36 as under. Next part. The taking note of the opposite decisions, it is crystal clear that the complaint, the FIR registered cannot be sustained in the eye of law. So, for the opposite reason, we are not going to delve much into the other issues raised. So, accordingly, the impugned proceeding stands and quashed. So, however, we do not wish to leave this issue at this stage, particularly when we have not gone into the allegation pertaining to other allegations on facts. So, it's such a matter we give liberty to the competent authority to present the service section 55 of this also Wireless Protection Act. Yes, with observed liberty, the appeal stands alone.
Obviously, if any complaint is filed, all issues on merit will be opened.
Obviously,
Lordship may just clarify.
Why should you say don't follow? They have not even started, so don't follow.
Because ultimately it may not come.
No, that's fine. We only said we are not going.
Deeply obliged.
Deeply.